Okay, sir, start.
1 minute. Oh. Okay, madam. Shall I start now?
Sir, give me a second. I'm starting.
Okay. The PPT is visible, madam,
Yes, sir.
and moving also, na?
Yes, sir. It is moving.
Okay.
Good afternoon, everyone. I welcome you all to the webinar on the topic claims settlement of workers during CIRP and understanding provisions of Labor Code 2025. Today we have with us Siva Prasad Puvvala sir as speaker. Let me briefly introduce Siva Prasad sir. Sir is qualified professional in CS, cost accountancy, finance, commerce, insurance and banking. He is having experience of 36 years in banking and financial services with cross-cultural experience and good knowledge in insurance sector. Sir has handled senior level responsible positions with higher level interactions and exposure. He has authored number of book study material for professional institutions like ICSI, ICAI, ICMA, IGNU, IIBF, Insurance Institute of India, Mumbai. Now, sir, you are requested to kindly start the session on the topic.
Okay. Thank you, madam. First of all, thanks to ICSI, IIP for giving me an opportunity to discuss about the claims settlement of workers during CIRP and understanding the provision of Labor Code 2025. As all of you know about the Labor Code, it was started in India, particularly on 21st November 2025 by the Honorable Prime Minister of India. The draft was happened long back and implemented some top 1,500 companies long back also. Now it was a full-fledged implementation with effect from 21/11/2025. So the IRP or RP is the chief executive officer of the company, the defunct company, during CIRP process. So the board for the IRP or RP is none other than Committee of Creditors and supported by the adjudicating authority in CLT also. Here, whatever the new rules are there, particularly regulations are there, or the regulations that are issued by various regulators that are relevant to the company, that is to be implemented if the company is a going concern. Once the company is a going concern, whatever the statutory guidelines are there, earlier the Factories Act or Workmen Compensation Act or Minimum Wages Act. So if the company is a going concern, you have to implement IBC prevail over the other acts. That formula is not applicable in that case. So once the worker is working, the Minimum Wages Act. And if the child labor, you should not engage. Or if at all the ladies are working, whatever the facilities, the prenatal or postnatal, whatever the leave is applicable, that is to be sanctioned. And if at all gratuity is there, or provident fund is there, or pensions are there, or whatever the social security schemes are there, that is to be implemented. So even though it is a going concern, we should not take the services of the worker for 24 hours. If at all they are going, they are particularly working for the organization, you have to pay the overtime. Even though the company is in trouble, that is a separate issue. And if the company is in trouble, you have to work for 24 hours. We should not insist because statutory laws and acts are there. So the claims settlement workers during the CIRP, whatever the workers 24 months, we have to pay in total before CIRP commencement date, whatever the dues are there. During CIRP, whatever it is there, this is a top priority on par with that particular CIRP cost. So all these things, if at all you have not implemented, then we will be in the trouble. We have to face some litigation, legal, etc., etc., etc. And the Labor Code 2025 is an important code. Today, big companies, they have to implement. Otherwise, lot of penalties, all these things will attract. Okay, the labor code is for the sake of the particular this one. So all these things we have to take into consideration in this code agenda. The claim settlement workmen or employees during CIRP, I will discuss. Understanding the provision of the Labor Code 2025 implementation 21/11/2025. That is also to be implemented. If at all the new or old cases are there, old cases, now it is going concern is going, they continue. You have to implement the Labor Code also 2025. Otherwise, it is very, very difficult and penalties. Sometimes a lot of issues from the workman union or the employees union, all these things. Once it is a calm period, because whatever the court cases attachment, all these things, it is, that is not to be implemented during CIRP. But this type of issues, Workmen Compensation Act, Minimum Wages Act, all these things to be implemented. That's why the IRP or RP daily has to discuss the matter with the HR officials, the HR department, the HR department of the particular company. So you have to ask how many workers are there, how many employees are there, what is their payroll, what is the basic, all these things. Then only smooth sailing will happen. Otherwise, extra problems will, if at all not implemented, we are inviting the additional issues or problems. So all these things I will discuss up to 5 o'clock. 3:30, we will take a 10 minutes break. Excellent. So why I have to implement the particularly the labor code? Why I have to implement? Sir, the some noise is coming, sir. Some noise. Put it in mute condition, sir. Put it in mute condition, sir. Okay. So the going concern. So once the company is a going concern, we have to implement. The primary role of the IRP or RP in a going concern under the IBC is to preserve and protect the value of the corporate data assets and manage its operation to ensure business continuity during the CIRP. Once the business is to be continued, then only the value maximization will happen. Suppose one machinery is there, we are not using that machinery. Over a period of time, what will happen? It attacks the particular rust, thereby the value will be deteriorated. Once it is a going concern, the buyers who are or the prospective resolution applicants who are going to take the company, some good results will happen. If at all I put the shut down the doors and the buildings are also dilapidated condition, if that is the case, the prospective resolution applicant may not quote the good price to take over the company. So the preamble also says, once it is the good company, possibility of a continuation of operations is required. That should be continued as a going concern. There is no secondary thought. That's why you're the CEO. You have to control the production department. You have to control the HR department. You have to control the marketing department. You have to control the finance department. Whatever the various functionaries are there in the company, you have to control. This is a crucial facility for company potential revival rather than immediate liquidation. Once the company is in not and going concern, definitely nobody will purchase, nobody will submit the resolution plans, then automatically the second stage going into liquidation. So as far as possible, it should be a going concern concept, running condition. And whatever the security, whatever the employees are there, as if you are the head of the company. You have to run the company, whether it is a real estate or pharma company or a chemical industry, whatever the type is there. That's why earlier I have conducted one webinar on what type of skills are required for sector wise also. No, sir. I don't have the knowledge in pharma. I don't have the knowledge in real estate. I know IBC code, whatever 256 sections or whatever the rules or regulation, I know pretty well. And judicial pronouncement, that is not suffice. That is not sufficient to handle the IBC cases by the resolution professionals. You are a businessman. You should have the leadership quality. You should have the communication skills. You have to control the people. You have to manage or conducting the COCs in an effective and efficient manner. And once you are handling that company in an efficient and effective manner, then all the stakeholders will be benefited. The crucial to facilitate companies' potential revival rather than immediate liquidation. The IRP or RP act as a crucial administrative facilitator. The IBC clearly told, okay, I require the knowledge of people in IBC law or code or rules or regulation. But at the same time, management of the company also. He is an administrative facilitator and a custodian of corporate data's business. That is your the whatever the 180 or 270 or extension of 60, 330, you are the controller, you are the administrator, you are the chief executive officer of that particular company to ensure survival potential. Okay. Sorry, earlier person, they are having good knowledge, they are unable to continue the company, means mismanagement or misappropriation of the funds may be there. That's why they are unable to continue the company. But today, you are not having that one. It is possible to continue the company in a better manner, maximize it during the insolvency resolution process. That's why, for going concern, you should update the knowledge of the labor code or whatever the government instructions from time to time. Okay, say take one example I am quoting here. You are you are the RP of one chemical industry. The chemical industry is a going concern continued, very good. But you have not renewed the particular pollution control board license. Are they allowed to continue? You should not talk, no, IBC prevail over that pollution control board. No, that is a part of the business, part of the running of the particular. Suppose I take, for example, you are continuing the company as a chief executive, the listed, the shares are listed in, say, Securities Exchange Board of India. Listing agreement and listing fees is not paid during CIRP. And they have stopped and they have imposed a penalty. Are you telling that, no, IBC prevail over SEBI? No, they say once you are continuing the company, whatever the formalities are there, whatever the statutory guidelines are there, that is inevitably you have to do. Inevitably you have to complete. Suppose I take, for example, you are the head of the company and the machinery or stocks are there. You have not taken the insurance policy. You are held responsible. Once the stocks are met with a fire accident, you are held responsible. It is not the part of the CIRP cost. That is clearly mentioned in the regulations also. So here, once you are continuing with the company as a going concern, all ought to be fulfilled. No question of IBC prevail over other acts. Verification of claims. We should not do the lacuna or dilution while verification of claims. Number of judicial pronouncements, some verification of claims is number of cases are dismissed on account of wrong claims included in the list of claims. So once the claim is there, whether it is a genuine claim or not, how to verify? The books of records available with the company. If the books are available, not available, the other ways and means. Today, whatever the transactions are there, all are available in the computer system. We should be well versed with the computer system also. And once you reported as a particular RP or IRP of the particular company, immediately first and foremost, you ask the systems administrator to come to your seat. How many are using the system? What are their user ID? What are the passwords? First, you disable that one. Otherwise, in the meantime, they may arrange, they may do some wrong practices also. Like that, whenever you are taking over the company, immediately you are they inform to the bank, stop the transaction. I'm going to handle that particular account, whether it is a current account or working capital account or whatnot, all. If at all you have not approached the bank, in the meantime, arrestable directors, they may withdraw the funds also. In the similar manner, the IT department also. Here, the claims, particularly to verify the claims with regard to the workers or employees, the HR department, correct? What are the registers and other things are available with the HR? What is the appointment order? What is the basic? What is the dearness allowance? How much housing rent? How much provident fund? Is there any NPS, new pension plan? What are the gratuity provision? Or whatever the TDS deducted from the salaries? All have to be verified. There is no exception at all. I'm busy with other areas, correct? Take the services of others. The accurate verification and inclusion of claims in the claims list is a fundamental and a critical responsibility of the IRP or RP during the CIRP under Insolvency Bankruptcy 2016. Diligent claim verification. I asked one person known to me, boss, how many claims? Boss, only 4 claims received, boss. I have submitted the same for formation for COC to the adjudicating authority. How many? 4 claims. Okay. What is the balance sheet? How many the liabilities are there? Have you verified? Have you checked this 4 claims with the available records? No. The casual approach is not good. Diligent claims verification by RP is a crucial for integrity, legal soundness, and a successful outcome of the CIRP. Ultimately aiming the fair resolution of us, the corporate debtors insolvency. Then only it is possible. Related party, unrelated party, financial creditor, operational creditor, if at all some claims both the financial and non-financial segregate that one, or the class of creditor like debentures or bonds or home buyers. Lot of exercise is to be taken in the claims part. That's why IRP role is very, very, very important. Once all this patchwork is completed, COC formed, then the RP will enter into the picture. Sometimes IRP may become the RP also. The CIRP under IBC requires a resolution profession to verify, admit, and settle the claim of all stakeholders, including workmen and employees. Workmen and employees. Trade unions are there, employees associations are there, their leaders are there, different parties affiliated, and some of the parties they will brought to the notice of the assembly if at all it is located in the state or central government in the parliament also. To avoid all these things, the workmen and employees, if at all any retrenchment is there, that's why in the labor code stringent norms are there. Suppose you are particularly you are appointed as an IRP. Now the labor code is in force. Simply, okay, remove all the people means, first of all, you take into cognizance of the union leaders. Sir, this is happening. There is no funds. There is no scope for production. Now, tomorrow onwards, for sufficient notice also to be given under labor code. Whenever you are taking new people, you have to give the appointment order also as per the new labor code 2025 with effect from 21/11/2025. The labor code 2025 notified and implemented with effect from 21st November 2025. It consolidates, it harmonizes, replaces the various earlier. Even IBC also. 11 acts are whatever the relevant portions are there, culled out and put the one code. This is not an act. IBC is not an act. Even labor code is also not an act. It is a code. Earlier, for pension, the woman, the woman employment or their maternity leaves or gratuity. So many acts are there. All are consolidated into the labor code with the 4 sub chapter. The codes are there. So the labor code 2025 noted the implemented from 21st November 2025 consolidates, harmonizes, replace the very like IBC. IBC is also code. Now it becomes a mandatory compliance framework for all corporate data under CIRP. If at all anybody is handling CIRP, they have to implement now. New people, they have to implement. Who are the earlier, those who are continuing as a CIRP, they have to implement the labor code. Claim filing. Workman employees must file the claim using Form D, Form E. For operational creditor who workmen, for operational creditor who are employees. Forms to be filled and with the interim professional or resolution professional filed with. So once it is filed, you have to call the HR manager, human resources manager, or personal department of the company. So these people are filed. So what is their records? What is their registers? Their service record? And how many they at up to what time we have paid the salary? Why we have not paid? All these information to be culled out by the IRP or RP. RP must verify employee records. Suppose I have paid I have submitted in a company, I am the worker, I have submitted 36 months salary. But the company is facing problem for the last 12 months. Why Mr. Prasad is claimed 36 months? Why the company is facing liquidation problem for the last 12 months? So that's why recently the financial creditor submitted the application with the NCLT. So cross-checking is very much required. Suppose on behalf of all employees or workers, the association leaders are also submitting, enclosing the list of the claimants, whether it is a worker or employees. and against each and every employee number, it is available records. Registers are available. Wage and salary registers. You have to verify. Attendance sheets. If the one person is absconded for the last 3 months or 6 months or 1 year, anyhow, the company is going in trouble, he submitted his claim also. That is to be rejected. Without a leave and all these things, he submitted the claim means at any cost, even though that is submitted by the group, that is the employees representative or the leader or the president of employees association, like that. We have to reject. Some of the people during this crisis, they, even though they have not come and they have working elsewhere also, they are submitting the claim. That is to be verified. Attendance sheets and PF ESI statements every month. Provident fund is to be recovered. Employee shares and employer share. And ESI contribution. Whether the contributions are sent to ESI or not, verify. So always operational creditor, particularly those who are supplying the raw material, or the financial creditor who provided the loan, or the home buyers, even home buyers also, the due diligence is required. Whether this is a genuine claim or not, with the available records, with the available, don't depending on any other. And HR approval records. Once the person is taken on the company record, the company normally issues the appointment letter and a reporting date and a PF number allotment, and every month PF deducted, TDS deducted, and whether it is credited to the respective salaries account or not, and a contract engagement letter. Suppose I require some the labor, gigi labor, or sometimes I will take some outsourcing agency. Today, if outsourcing agency contractor not paid the amount to the labor also, that is to be paid by the corporate data. That type of stringent norms are there in the labor code. You have to pay. No question of IBC prevail over other act. Once during CIRP, if at all you are taking these services, you have to pay. It is a part of CIRP cost. Understanding order and code of conduct. Unregistered informal labor claim verification relies on industry norms, muster rules, HR affidavits, and NCLT precedents. If at all any NCLT given directions also, you have to implement. CIRP cost under IBC, Section 5, subsection 3, 13, and Regulation 31. Wages, salaries, employees, workmen for the period of IRP or RP post CIRP to be treated as a CIRP cost must be paid in priority. Once I am taking the services, the company is a going concern. I am purchasing raw material. I am taking the services of the labor. I am taking the electricity, all these things. Once I have not paid, next month onwards, they will not come. Here, don't wait, don't delay this payments. Once after CIRP, if at all the company is a going concern, once you are taking the services of employees or labor, we have to pay. There is no other option. Please wait. The resolution applicant, I will ask them to pay. That type of questions are irrelevant. If at all you wish to continue as a going concern, out of the total crimes, 10 not exceeding 10%, if at all unencumbered securities are there, put it in any finance company at the bank and take the interim finance and run the company. Priority of Jews. The core interaction of the section 53, liquidation of a waterfall mechanism, which ranks the order of debt repayment. Workman dues, the dues of the workman 24 months preceding the CIRP date rank equally with the dates of the security creditors. So once the company is in liquidation, the 24 months, if at all 36 months not paid, you have to give only 24 months. That 24 months, most of the claims were cleared. Normally, the 12 months or 18 months, the workers or employees will not tolerate for a delay, otherwise their living condition. But in the code, the broader area, 24 months they have given for workers, those who are working in factory. Employees means those who are working in the administrative offices. There is a wide difference between a worker and the administrative staff, employees. Employees dues won to the other employees for a 12 months preceding the liquidation, slightly lower priority than the secured, but higher than the unsecured creditors and government dues and pre-CIRP dues. The workman period prior to the insolvency commencement, whether it is an operational date, it is an operational date and subordinate to CIRP, rank equally to the operational unless covered under liquidation form. So all these precautions are to be taken into consideration by the IRP or RP. Workman dues have the following order. Workman dues the preceding 24 months. Secured creditor relinquish the security paripasu equal. Not equal, not divided by 2, based on the amount. How much amount of the workers, how much amount ratio, and whatever the amount is available, according to ratio you have to pay. That's why it is called paripasu. And the next priority employs 24 months. Procedural changes. IBC Amendment 2025 introduced aim to further clarify the priority of dues specifically by ensuring government claims arising solely from the statutory charges do not rank as a security, which reinforces the establishment of the hierarchy for the benefits employed dues over the government claims in the waterfall mechanism. Even government is also sacrificing the dues. They are giving top priority for the workmen or employees. Operational creditor status. Employees and workmen are classified as operational and they can file the claim with the interim resolution profession. Even the workmen or the employees, they can file an application with the NCLT under particularly to initiate CIRP if the total amount is more than 1 crore. And now coming to the reforms. 2025 reform. 2025 reform. That is a 4 comprehensive labor codes. That is a 4 comprehensive labor codes. So sometimes it may be repeated. Why? Because this is a new code. Proper understanding is required. Sometimes I will repeat the concept once or twice for familiarity's sake, etc., etc. The 4 codes are in force. Now in force. What are the codes? The code on wages 2019 and the Industrial Relation Code 2020. Code on Social Security 2020. and Occupational Safety Health Working Condition Code 2020. The four combination is called Labor Code 2025 reforms to be implemented from the 21st November 2025. The Honorable Prime Minister also given they introduced this one, and they have given wide publicity by the Ministry of Labor and Employment, Government of India. So the code wages 2019 code, Industrial Relation Code 2020, Code on Social Security 2020, and Occupational Safety, Health and Working Condition Code 2020. Combination of these codes, four codes are called the labor code. If at all you are handling any manufacturing company or a labor intensive company like real estate and other things, definitely this labor code properly implemented during your tenure or prior to your tenure. Now, most of them are during your tenure only. If at all you are going to handle another company which is handled by IRP or RP, that also you have to verify whether the labor code is properly implemented or not. 2025. If at all any issues are there, resolve that one along with your IBC code. Otherwise, it is a difficult one, and it attracts more penalties, and whatever the legal issues are there, we have to face. Once we are in going concern, and particularly IBC prevail over other acts, no attachment, no court orders like that. But for this, it is an exemption. Once you are taking the services of the people, you have to pay properly as defined by the Labor Code 2025. The purpose of this Labor Code 2025, with effect from 21st 11 2025, the reform intends to modernize India's labor regulation, reduces fragmentation, makes compliance easier, broaden the social security, improve worker welfare, and align with the contemporary employment practices. Gig workers, contractual workers, platform-based workers, etc. Today, we are taking the contractual workers and gig workers also. Temporarily, we are taking services of the workers for completion of the tasks. For all these things, in the labor code, it is clearly defined. The platform course, the based work also, through online, we are taking the services of the people. That also, the guidelines are issued by the Government of India. For employers, it means a shift from confusion of overlapping laws to unified and more predictable framework. But also new compliance requirements. Documentation is also there, and the responsibility is also fixed under Labor Code 2025. So no new compliance requirement. And once you are continuing the labor, you have to send the returns also to the labor and employment, labor and employment, the labor employment department also, and predictable framework. All these things you have to. Minimum wage means you have to pay the minimum wage. Otherwise, don't take. Otherwise, don't continue the company as a going concern. If at all the funds are not matching to the cost of production, or cost of production is higher than the revenue, and take the approval from COC, and take the inform to the union leaders or association, and remove the people, and they go for either immediately the resolution plan or liquidation. Whatever the best mode is there, subject to approval of COC, subject to approval of the adjudicating authority. The key provision, because it is the labor code, code wise or issue wise also I will discuss. And code on wages 2019. These four codes are clubbed together is called labor code. So if at all you are handling any corporate, whether your HR department, human resources department, or personal department, or if the name is manpower department, whatever the name they have defined, that whether they are implemented that code and other areas or not, that is to be overseen by you. I'm not talking you. You verify like that. You have to you have to know about this one, and you have to interact with the HR department whether they are completing that type of tasks or not. One is the code on wages 2019. Unified wage definition. Wages now are standard definition across the sectors and laws replacing earlier varying definition. Today, on account of labor code, across all sectors, the standard definition is there. Wage means earlier different sectors, different the definitions, different the particularly the amounts, all these things vary. Now it is standardized. So the wages now standard definition across the sectors and the laws replacing the varying definition, and national floor wage plus minimum wage guarantee. Minimum wage obligation now apply more broadly to both organized and unorganized sectors also. Suppose if at all I am taking a daily labor, it doesn't mean that whatever I wish to pay, that is not correct. Minimum wage means whether it is organized or unorganized. Even for that sake, if at all agriculture labor is unorganized, contract labors are unorganized, it doesn't mean as per their wish they will pay. No. Even take for example road contracts or project contracts, you have to pay the minimum wage act, covering many workers who are earlier might have been outside the minimum wage protection. Now all are comes under all end to end, all types of manpower. Now they are comes under minimum wage protection. Timely wage payment and mandatory appointment letters. Timely wage payment. No, funds are not there. Liquidity problem is there. How he will survive? The workers who is getting peanuts, not a rich man, and a mandatory appointment. Suppose if at all he is working and attendance, and if at all any organization is not given any letter, how he will approach the court that company is not paid to me. That's why appointment letters are to be given, and timely wages next month during following month, the first week the wages to be disbursed. No liquidity problem, CIRP, that the I have to pay that one, this one, this one. No question. No question. So here all these things, timely wage payment, mandatory appointment. Employees must issue formal appointment letters to all the workers, ensure timely salary payments. That is also required. Next one is overtime and wage discrimination rules. Earlier, for a woman, different rate. gent, different male or female, different wage structure is there. No, no gender difference today. And overtime means earlier some of the companies they work normal wages. Once the overtime, first 2 hours, this much, they 150 of the per hour normal rate, or that 200%, 300%, that the overtime wage rate has to be increased. Earlier, what the industries or companies or the real estate or the infrastructure they are doing, simply if per day 10 hours, 10 rupees is there. And if at all he is working extra hours also, per hour 1 rupee they use it to pay. No question. Next, after the working hours are over, if he is engaging the service of the same worker with a higher rate, that also defined in this the wages, the code, the wages code. Overtime and wages discrimination rules. Overtime must, as before, paid at a higher rate, and wage discrimination based gender other than protected category is prohibited. Prohibited. Now coming to wider coverage. Wage payment and minimum wage obligation now cover many previously excluded categories. Earlier, the workers they used to pay as per the wish the company. Today, the minimum wage is applicable to all, whether it is a part-time or full-time or hourly basis. The minimum wage is stipulated. So it is a wider coverage as per the wages code. That is a subcode of the labor code 2025 with effect from 21st 11 2025. Implication for the corporate data. Once all these things are there, definitely the wage cost will increase. Earlier wage cost is low. After implementation of this labor code, now the companies are worrying about the increase in the wage cost. The implication of the corporate data. Payroll structures may need to be revised. Today, even though you are handling the CIRP, even though you are handling the CIRP for the last 2 months, and after 2021, you have to revise, revisit whether we are paying as per the labor code, wages code, subcode is a wages code or not. You have to verify. You have to verify and revise that one. If at all anybody is approached the court, IBC prevail over other acts, that formula is not applicable in this case. Once you don't require the manpower, you have to address suitably by inviting all the workers, inviting the union leaders, tell this company is like this, the financial problems are like this. That's why we are unable to pay, we are unable to run the company. Even whenever you are removing the people also, the proper notice is also to be given under the labor code. That's why I requested madam also, why not conduct this the particular webinar for the benefit of the resolution professions. Payroll structures may be revised. Need to map wages as per the new definition when computing basic allowance and overtime. So before 21st overtime is different. After 21st overtime is different. Before 21st November, the basic pay is different. After 21st different. Dearness allowance, whatever it is, their provident fund, all as per the new code. You have to take the services of expert, professional, independent professional, whether the HR department is doing correctly or not. Ensure all employees regular, contractual, part-time, gig or platform linked have appointed letters with clear terms. After 21st, today, almost all HR department or personal department or manpower department of company, they are busy with the preparation of the offer letter by stating the revised basic whatever the allowance, whatever the overtime and all these things. Minimum wage compliance, especially for lower level staff, must be reviewed in line with the state level notification. So it is a central code, but some of the areas state specific is also there. Since the floor wage determines state set minimum wages, depends upon the cost of living, depends upon the particular. This one, take for example, minimum support price is there. Minimum support price is varying crop to crop. Like that, here also some states, so even a state also, the labor employment, the department is so they will also say the government of India, Ministry of Labor and Employment, they have communicated this one to the different states also. Maintain strict discipline in payroll, timely payment, and avoid discriminatory pay practices. And within the group, known persons are higher salary, unknown persons are lower salary. That discrimination, the private organization, they are doing this type of malpractices. So, CIRP during the CIRP, if at all you are handling the company and the company is a going concern and the company is also engaging the labor and employees, you should not give any scope for a discriminate of the salary for same work, same skills, no discrimination, nothing. Code on Social Security 2020. Under the labor code, the second code, first is wages code. The second one is security code, code on social security. So in the plant and machinery, in the minings, or in the roads, the social security, the whether if at all wages, the workers and employees are there, you have to adapt to the social security schemes. What are those defined under labor code? Universal social security coverage. The code extends social security to all workers, including unorganized sector, gig workers, platform workers, contract workers, etc. No, social security is only permanent employees. Social security is only for full-time employees. No, it is all people, even though gig workers, temporarily I'm taking some people for completion of the construction. For that also, I have to take care of the social security that are defined under the social security code under the part 2 or chapter 2 of the labor code 2025. And they expand the coverage and the ESI employees state insurance, the companies and the provident fund and the gratuity. The social security network, that is ESI, is now widened pan India. Previously notified areas and a threshold holds may not apply. So now employees state insurance. Earlier only notified areas. No question of notified area. Earlier this much minimum salary. This is a minimum basic. Today that all are removed. Workers means workers. Whether it is a low level worker, not eligible, high level worker eligible, that type of a discrimination is removed. Employees even smaller or previously excluded establishment may now this have the operation. So the medical treatment, honestly speaking, some of the employees, workers, It is particularly blast furnace unit in steel companies or in pharma companies, wherever the composition of the formulations are happening, lot of smell, lungs cancer, lungs problem, skin cancer. But he is a part-time employee or low-level employee. ESI is not covered means the sick, the sufferers are more. That's why ESI is to be applied to all the people. No exemption. If at all I am sitting in an office where no smell, no radiation, nothing, I am getting ESI. But who is suffering with the production department and he is sacrificing life. He is denied or deprived of ESI. That is not correct. So that's why if you go into the code, this is also there. Inclusion of gig workers, temporary workers, for the time being, platform workers, and online and work from home aggregators. The law is recognized gig workers, platform workers, and aggregators also. They are also eligible. They are also to be covered. Social security schemes like ESI or gratuity or the Provident Fund or whatever the national payment pension scheme, etc., etc. Platform and employees may need to contribute to social security fund for such workers. Employers may need to contribute social security fund. If at all the fund is not established, then how you will provide this the social security scheme to? So you have to provide the fund also. Why all these things are there? Once the company is a going concern and the employees are there, wage workers are there, you have to apply. There is no second thought. And once after CIRP commencement date, no question of once you are using the people, particularly employees or workers, you have to apply. Otherwise, a lot of problems will arise to the resolution professional. No, sir, this is a defunct company, sir. Funds are not there, sir. That's why I have delayed, sir. That month and I have not paid, sir. Nobody will. If at all, it is not possible, tell that the company, it is not suitable for going concern. Benefits of fixed term employees, contract labor. Even fixed term employees and contract laborers are entitled benefits of similar to permanent leave, provident fund, gratuity, social security. Earlier, only permanent employees monthly, one casual leave and per annum 30 days the privilege leave. No question. No question. This is applicable for fixed term employees, even contract employees also. Once the contract employees are they doing, no, I will pay my daily and no question of leave. You have to provide the leave also. 1 day per month. 30 days completed means 1 day the privilege this casual leave and 1 day privilege leave and sick leave also. Earlier, only the permanent employees. Today, there is no distinguish between a permanent or gig workers or a temporary employee or contract labor, etc. Simplified compliance and administration. Social security contribution, compliance, registration, and paperwork are streamlined under the unified code. Like IBC code, formats are there. For CIRP, for public announcement, this is a specimen. For claims, this is a specimen. For operational creditor, this is a specimen. For operational creditor as a group, this is a specimen. Class of creditor, this is a specimen. Form H, this is a specimen. Like that here also in the labor code, all forms are designed and it is a beautiful one. Like IBC, labor code is also streamlined like anything. So the simplified compliance and administration, social security contribution, compliance, registration, and paperwork are streamlined under unified code. IBC also unified code. 11 acts, whatever the relevant portions culled out and formed one code, that is IBC. In the similar manner, 29 acts with regard to the particular labor or the workers or employees, all are clubbed together and remove whatever the garbage is there, remove that one, and they formed one code that is called labor code. Implication of the corporate data on account of social securities. Companies must re-examine all categories of worker permanent, contractual, gig workers, platform linked to access to social. So scrutiny is there. They will do. They will verify. One inspector or the independent auditors are also there. They will verify, re-examine. The gig worker platform or contractors ensure correct classification. So, security registration, contribution welfare for each and every person, like a provident fund number is a social security scheme, pension fund, social security scheme number, ESI. So, a unique number to cover all these things that is to be the allotted, and every month that is to be credited, whatever the social security scheme, PF, ESI, other countries must be recalculated earlier, that is 21st before one wage, 21st after different wage as per the labor code. You have to recalculate ESI, you have to recalculate the provident fund, you have to recalculate the gratuity. New rules portfolio for all eligible workers. Earlier, the temporary or part-time, they are not eligible. Now they are also eligible. All social securities are to be revamped. If at all some companies, IRPs or RPs are running, they have to verify this one also. Administrative and compliance systems, payroll, social security, record keeping may need revamp to adopt the unified code requirements. The unified code requirements, that is very much required. All are revamped. One country, one nation, one GST, that is tax, one tax. Like that, for resolution also, the IBC, for labor also, one code, one nation, one code, not 29 acts, earlier 29 acts. Third one is the operational safety, health, and working condition code. So, if at all the plant and machinery, high risk is there, wires are handling, shock is the electricity connections are not there, good conditions are not there in the production department, and if at all anything happen, then the employer is liable. In this case, CIRP, we are liable. So we have to take the services of the HR manager, and the HR manager role is to implement that one. Our personal department role is to implement that one, or the production department has to play a vital role in this regard. But we have to supervise whether they are implemented or not. Otherwise, going concern, stop it. If funds are not there for modification of safety measures or health or working conditions, tell the COC, get the approval. The going concern is not possible. To provide the labor code, this much amount is required. If they approve, with the help of a manpower or personnel or HR department, implement that one. The third subcode of labor code is occupational safety, health and working condition code 2020. Unified national standard for occupational across all the sectors. They have defined or designed safety precautions, how to take the safety precaution, health of the workers, working conditions across sectors, manufacturing, service, hazardous industries, there will be standardized requirement. That's why this is called the unified code. Earlier, they whatever nonsense, different, some sectors they have implemented, some sectors not mandatory, regulated, unregulated, so many kachada things are there. Now it is standardized. Safety, welfare, and health provisions are expanded. Earlier, with the nominal safety measures, with the nominal health provisions, no question of it depends upon the number of workers, the medical officer should be appointed. Earlier, the corporate data, they violated. Because once violated, the cost will reduce, the profit, they will enjoy the profit. Today, to run the companies, it is difficult for the corporate data. Strict code is there. Safety, welfare, and health provisions are to be expanded. Applies to all contract labor. The safety. No. Today only one day I have taken, or 1 week I have taken, or 1 month I have taken. Why should I provide safety measures to them? No. Whether it is a contract or informal worker or gig workers, hazardous industry workers, and even small establishment, the guidelines are there. Certain conditions or guidelines are there. The safety is very, very important. Earlier, all companies, they violated, and once they violated, the cost will the reduce and the profit they enjoyed like anything. Today, that is not there. Mandatory health measures, including annual checkups, health checkup. Whether he is facing any skin cancers, or skin diseases, or lungs problem, or diabetic, or heart problems, or other ailments, or bone problems, that some cases they have identified with the company's cost, not employer's cost. The employee's cost, employer's cost. Workplace welfare, accident coverage to ensure the worker safety and well-being. That is the power of the labor code. That is to be implemented. This is the ILO, International Labour Organization. Even IBC also, the International Monetary Fund, they have given pressure to the government. Implement. Like that, the ILO, International Labour Organization, that who are the members of the country, they defined, no, don't tell about 29 acts, only one code to cover all the areas. Even earlier, 11, the insolvency and the bankruptcy spread in 11 acts and consolidated that one and formed one code, that is IPC code. So on account of this one, again, it is a burden to the corporate data. Once it is a burden to the corporate data, during CIRP process, it is a burden to the IRP or RP also. It is an IRP or RP role also. What is that one? Companies need to review workplace. Hygienic conditions are there. Water logging is there. electricity wires are in proper or not, any shock treatment is happening or not, and any smells are originated, fumes are originated, that the production manager or the HR manager, they have to look the overseas by the IRP or RP during CIRP. If that company is a going concern, that company is in a manufacturing process. Welfare, ensure compliance with the national standard and requires a safety infrastructure. National standards for electricity connection and dim lights. Once a dim light is there, once he is working in a plant machinery, if a dim light is a probability of accident. For units with contract temporary labor, hazardous operation, ensure safety norms, insurance coverage. Today, what is happening? Particularly flyovers, the L&T, that NT, subcontracts, night time, during traffic time also, the cranes are lifting the heavy the objects. If at all it is fallen, first the labor will be affected, thereby the public will also affected. And the insurance policies to be taken. Once they are handling the dangerous works, the life of the labor, the personal accident insurance policies. If at all it is a chemical, the health insurance policies to be taken, then start the work. Temporary labor hazardous operation, ensure safety norms, insurance coverage, and welfare standard irrespective of the work type. Continuously, if at all the worker is working for 8 hours, the fatigue will lost. The probability of the accident will increase. So the risk assessment, safety audit, and record keeping should be strengthened to meet the code compliance requirements. Safety audit is required. Whether if the worker is working in that particular environment, whether he is in safe condition or not, safety audit to be completed. Then only ask the worker to work. Otherwise, simply violating our norms, particularly real estate. How many people are died? Nobody knows. The corporate data, they are managing the show, and they are the contractors, they are doing wrong things also. But the labor code gives a scope to these people not to do that one. First, all are safety condition. So in the coming days, manufacturing or real estate or infrastructure, it is the biggest problem for the corporate data. So, with regard to the resolution professional, because we are the CEO of the company and we are continuing the company as a going concern, all these measures are in place or not, we have to verify. Otherwise, the problem will arise to the IRP or RP also. Industrial, that is a lost code under the labor code. Industrial relations code. So we have to maintain cordial relationship with the workers union, employees union, all these things. Otherwise, the problems will create. Whatever the decisions you are taking, while the particularly the placement or whatever the measures are there, you have to contact the union association people, industrial relation. Otherwise, divide the people and the work. That is a great benefit to the corporate divide. Divide and rule. Now it is not possible. So the worker union, all these things. Simplified industrial relation framework to code stimulate dispute resolution, union recognition, collective bargaining, employee and employee relation under the unified structure. This is also defined in the code. Earlier, no, this gated community, no union, nothing. So they are bringing the people from different villages in a lorry, and they are completing that whatever the works are there. Today, that is not possible. The code streamlines the dispute resolution. Whatever the disputes are there, the employers, that is to be discussed with the union leaders, collective bargaining, and employee relationship improved to get earlier to earn more profit. They are doing so many wrong things. Applicability across the employment rights. The code covers permanent employees, fixed term, contractual, gig, platform employment, making regulation more uniform. This union leaders or association or collective bargaining, not only for the permanent employees, even part-time or gig workers also, the same structure is adopted. Reduce the compliance burden and modernization. The consolidated code helps the business reducing the overlapping loss and simplifying the licensing, registration, filings, returns, and legal compliance across all the structures. Earlier, different formats are there. Some formats we have to send to Labor and Employment Department, and how many, what measures we are taking, how much any accidents, all these things all are standardized and unified. No question of different sectors, different formats. All our standard templates are designed and implemented in this code. That is the beauty of the labor code, like IBC code. Even IBC code also, forms for liquidation, 1, 2, 3, 4, forms for CIRP, forms for PPIRP, forms for personal guarantor to corporate data, forms for liquidation, forms for voluntary liquidation, standardized formats they have defined. In the similar manner, the labor code also. Implication on account of this one, what is the implication to the corporate data? HR and legal terms must be align employment contracts, industrial relations policy, union collective bargaining framework with new code for companies with industrial labor or unionized workforce. The transaction to be new code may change the process of recognition, disputes, layoffs, retrenchment also. Whenever the layoff is there, wherever retrenchment is there, simply today evening they told, we are a layoff for this 100 workers. No question. You have to give sufficient time to give well in time the notice to the workers also. If at all you are layoff or retrenchment the workers, tomorrow he may not get it. The employment. And need to review the existing agreements. Whatever the existing agreements are there with the particularly the labor engaged by the through various agencies, that is to be they revamped with the new laws, new code, labor management practices, internal policies to ensure compliance with the new unified relation code. Now, on account of this one, what it means for companies or industries and strategic or compliance perspective also. Whatever I have told earlier, with regard to industries and companies, what is the implications and what are the compliance or what are the strategic thoughts they have to use, all these things under third part I will discuss. After that, Again, I will go to that particular IBC, the IRP role also. If at all he is not implemented, we have to invite the complications. We have to invite the legal issues. That also I will discuss after that. The simplified compliance and the lower administration burden. With the consolidation, employees now deal with a unified framework on one registration, one license, one return, reducing the complexity and the compliance cost. Today, even though this much restrictions of four courts are there, the corporate data or employees need not worry. The compliance part is also simplified and a lower administration burden to the companies also. With the consolidation, employees now deal with a unified legal framework, one registration, one license, and a return to be submitted by the employers, reducing the complexity and the compliance cost. Wider coverage, more workers under statutory obligation. Companies may have extended benefit to social security, safety measures to many categories, all types, gig or a contractual or small establishment, who earlier might have not come under the statutory ambit. Need for update, the companies are need to update the HR, payrolls, benefit systems. Payroll definitions are changed. Accordingly, you have to give more remuneration to the workers or employees. Their benefits like a PF gratuity and ESI. Contract appointment letters you have to give. Earlier, you have not given the appointment letters. Today, even temporary workers are also need not be a permanent one. You have to issue the appointment letter by stating the what amount you are going to give. Safety, welfare policy need review. Potential increase in cost. Once all these things are implemented by the corporate data or the company, wages, security, all these things will increase. With minimum wage floor is increasing, social security coverage is also increasing, equal pay norms to all the people. There is no distinguish between lower and higher. Overtime is increased. Gratuity benefits are applicable to all types of people. No question of permanent, even temporary and limited period also. Fixed term workers, companies may see higher labor cost. On account of this one, the labor cost is increased like anything. Improved workers' production, clarity is there, but also more employer accountability is also there. Worker welfare, he has to take care of. Worker safety, he has to take care of. Social security firm, he has to take to ensure compliance or risk penalties. Otherwise, he will attract the risk penalties also. Better formalization and more transparency for workforce planning, compliance audit, internal governance, formal employment contracts, reducing the gray of informal practices. Once this is implemented, whatever the earlier the informal practices that are there by the corporate data, that will reduce drastically. And the flexibility to adapt modern employment forms. The code reflects realities of a gig economy, platform work, contractual labor, giving legal framework and support the new business employment models with the obligations. Earlier, some of the people, they are on temporary roles. The employers are not giving any the offer letter or the employment letter. Today, if at all they want to work in any organization, they are asking experience. Today, that experience on account of the temporary workers, no offer letters or employment letters, then they are deprived of this function. Today, every employee should have the appointment letter. whether it is a temporary or giggy workers or a short duration or part-time, anyhow full-time, they will get it. Key actions to be company should be take compliance roadmap. Actions. What are the actions to be taken by the companies? This is also useful to the IRP or RP. These are actions to be taken by the companies. If at all the defunct company you are going to handle and the company is a going concern, definitely you have to take care of these things. What are these? Review the workforce classification. First and foremost, how many workers are there? How many employees are there? And audit of all workers. How many are permanent is there? How many are contract is there? How many gig workers are there? How many platform workers are there? How many part-time? First and foremost, if you want to continue as a company as a going concern, you have to do and classify as per the new definition. For each, check what obligations to apply, whether to increase the wages or social security or safety or benefits. So being a IRP or RP, you have to close contacts with the HR department or manpower department. And how many people are there? What type of people are there? Production department, how many? In real estate, how many labor is working and how many employees are working, the payrolls, all these things. Whether as per the code, it is you have to supervise, but at the same time, you have to take the services of the experts in this regard, subject to get the confirmation from CIVOS. Update the employment paperwork. Whatever the earlier, suppose you take for example, if at all you are in one organization, wage revision is there. Once a wage revision is there, what they will do, whatever the old basic is there, they will pay the old basic. If at all DA is revision, DA, whether if at all any perks are there, additional perks, all this in the similar manner on account of labor code from 21st 11 2025 onwards, you have to revamp that particular the salaries and wages of the workers as well as employers as per the revised labor code 2025. Ensure every worker has a proper appointment. If at all part-time people not given appointment letter, now please issue. Otherwise, violation of labor code. If you see the violation part, that is also serious. Let us specify the terms, the wages, the working hours, the benefits, etc. Reconfigure payroll and benefits, redefine wages for salary structuring, ensure minimum wage compliance. Earlier, they have not paid minimum wages. Now there is no other alternative except to pay the minimum wages irrespective of the sector. Rationalize overtime calculation. If at all earlier for morning to evening, if they did 8 hours, 8 rupees per hour, 1 rupee, 9th hour, 1 rupee, 10th hour, 1 rupee, 11th hour, no. Once the hours are increasing, the overtime rates are different rates are there. That is to be applied. And wage compliance overtime calculation, time wage payment, and earlier, as per his wishes, as per the funds available, he will pay. Last 2 months back salary, now like that. Timely wage payment, PF, ESI, social security contribution, all these things are to be revamped, reconfigured. Extend social security and safety measures. So extend social security and safety measures for all eligible workers, including contract, gig, or platform small establishment, arrange ESI, PF, insurance, and other required benefits implement and safety health standards also. And update HR industry relation policy. For unionized workplaces, The industrial labor revise the collective bargaining, dispute resolution, and internal grievance redressal, contract fixed term employment terms. So now again the role of the unions will come into the picture. So in the code also they clearly mention they have to take into cognizance of the particular union leaders while revising the salaries or whatever it is there, the union president or this one. Ensure complement documentation. So as per the new definition 21st, that the 11/20/25, the registers, what type of registers are to be maintained, what type of returns are to be sent to the Ministry of Labor Employment, and what type of licenses are to be obtained, unified regime, and this is to be complied. Be ready for inspection, audit under the new code compliance requirement. Not only that one, plan for increased cost. So today, on account of this revised norms, the labor code, you have to, the labor cost will increase, the wages cost will increase, and budgeting also is required. Additional earlier, suppose I take for example, in that particular company, earlier, they per month, 10 lakhs are there for the payments of salaries and wages. Today, on account of the labor code, you have to pay nearly 13 lakhs or 14 lakhs, that much provision to be maintained. And since labor cost increases, wages or benefits of social security, revise their financial planning models accordingly and get it approved from the COC also. So once you are paying a higher amount, and these costs are to be approved by the committee of creditors, and whether it is economically viable or not, as a going concern, that is also to be taken into consideration. Employees in a regional industry context. Even small industries, contract-based workers, informal or gig or outsourced staff now may fall under the statutory compliance. So you must audit all the stuff. Even small industries also. Earlier, the small industries, they don't follow anything about the labor. Today, once the company is registered, once the industry is registered, definitely they have to do all these things. For companies using contract labor or gig workers, logistics, particularly the employee, the buses or cars or the from some certain place to the factory, you have to provide the logistics also. Delivery platform based staffing must access the PF and security, safety, and ensure compliance. So in the coming days also, the companies have to develop the application apps and how much salary they have paid, how much ESI or PF. That is in some organizations, that the internet and that HR the software is available. Human resource development software is available. In the coming days, the apps are also to be developed based on the need. Payroll and HR systems are to be updated. Timely wage payment, structured wage component, PF benefits, overtime leave, and other things, safety and occupational health measures. Even the companies are to be taken. Even small company need to be standard requirement. Risk assessment, health checks are required, wealth benefits are required, safety compliance is required. Become more critical also. Budget for possible high wages benefit outflows, company must plan accordingly. Once it is implemented, the outflow will be more. The outflow to be properly addressed by the companies. And the key risks, challenges for companies and management. What are the key risks and challenges for the companies management? We will discuss after tea break. Is it okay for all, sir? 10 minutes tea break. Is it okay? Hello.
Yes, sir.
Okay, sir. 10 minutes tea break, sir. Shall I start now, sir?
Yes, sir.
Okay, sir. Okay. Now, key risks and challenges for companies and management, particularly on account of to be implemented or implementation of this labor code, cost escalation will happen. With increase in the minimum wages, benefits, social security, labor, cost may rise significantly. And the compliance burden of a previously informal workforce. Many sectors with a contract, gig, or informal workers now need to formalize and compliance overhead and record keeping of overheads and potential administrative resource compliance are also allocation also increase. Next, transition risk, particularly old to new code we are coming 29 to the 4 codes and the contracts of payroll structure benefit schemes might need to overhauling the risk of non-compliance during the transition. Uncertainty until of state level rules to be notified. And in the meantime, the state also they are developing based on the code. They are also developing some norms. That norms are also to be fulfilled by the companies. Although central codes are in force, detailed rules, especially the social security, state level minimum wages, and safety regulations may be notified by states. Companies must track, particularly in my state, notification, track the particular every state, whether it is a Telangana state or other states. And operational adjustments are also for industries with a contract or seasonal or gig labor process, contract labor, hiring, onboarding, or benefits of the payment or social security will need to rework, possibly affecting the flexibility of short-term staff, the strategies, etc., etc. Overall assessment, if you take what employees should do right away. And employers means the corporate data only. In this case also, you have to pay special attention being a RP or IRP during that the 180 or 270 or 330 days. Conduct a full audit workforce, full-time, part-time, contract, gig, outsourcer, and map obligation under new code. Update HR payroll benefit compliance, safety policies of the company also to be verified, and the appointment letters, wage definitions, social security safety documentation. All these things are to be verified by you. Build internal capacity and engage consultants. Today, I told that's why for this all these things, the IRP, RP, if at all fully involved, then the core activity will lost. That's why you have to engage the consultants, compliance experts to ensure the smooth transition and avoid penalties that is required. For this also, you get the permission of a committee of creators to implement that one. And not only that one, particularly one thing, sir. Okay. Now coming to the update payroll and benefit all these things, build internal or capacity to engage. And not only that one, plan for increasing cost is also there. So for that, you have to provide some provision. Keep a track of the state level notification. That is also one of the area. The next one is the fourth, labor code interacts with insolvency and bankruptcy code. how the labor code and the IBC interact with each other. And some relationship is there. That's right. What is that right? New labor code effective from so and so primarily interact with the IBC. Through provisions concerned, the priority of employee dues during insolvency proceedings and enhanced social security measures. So being an insolvency profession, you have to read, you have to implement. Implement means not by you, through the supporting staff only. And why the implementation is required means to avoid the penalties. Because you are the helm of the efforts with the supporting of the COC as well as the adjudicating authority. So that's why there is no other alternative except the RP or IRP to oversee this one. In case of liquidation also, if at all it is a going concern, in that case also, the liquidator is also to be answerable for the any lacuna or mistakes. Labor Code robust framework for workers' rights. While IBC established mechanism of the priority for settling during the company financial distress. Okay, this is the workers' right. One is the code. The second code is also giving importance to the workers also. Key areas of interaction. What are the key areas of the interaction? Labor code reinforces the importance of timely payment of wages and expand social security. But IBC waterfall mechanism ultimately determines the priority in insolvency ratio. Ensure that they are addressed before most of the other claims. So IBC the labor code is a timely payment. IBC is also waterfall mechanism. The priority is there. That is to be addressed properly. Protection of benefits. Statutory duty like Provident Fund, Pension Fund, and Gratuity Fund do not form the part of the CIRP and the liquidation of the asset. Therefore, protected from the insolvency process. Whatever the Provident Fund is there, whatever the Pension Fund is there, that is not to be attached in the IBC process. That is separate. We should not touch it. That is funds contributed from the salaries of the employees of the organization. The new labor code expands the social security coverage to all the workers, including organized or gig or this one, or ensuring more individuals have protected statutory benefit for remaining ring fenced during insolvency also. So here the labor code covers a number of people during CIRP also. If at all any they particularly unorganized or gig workers are there, that is also to be covered under the social security schemes of the particular labor code. The procedural changes. The labor code introduces the inspector cum facilitator system and a mandatory of a 30 days notice period for compliance issues, which may streamline some interaction between the company and the labor authorities, even pre-insolvency distress situation also. So here in the code, they have introduced inspector cum facilitator. So whatever his observations are there, his observations are to be tagged properly, and he will give 30 days notice to the company. So if at all you are in the particular company, you have to obey the instructions of the inspector cum facilitator. Whatever his observations are there, he is from labor authority. So the company has to fulfill that one. Being a IRP or RP during the CIRP process, you have to answerable to the inspector cum facilitator. We should not talk about the IBC prevail over the other act. In the essence, the labor code ensures broader scope for the work entitlements, while IBC provide a legal structure for how entitlements are managed and prioritized when the company faces insolvency, ensuring employee welfare is the significant consideration in distribution of assets. Now, interplay of the Labor Code 2025 with the IBC. So, the key features of the Labor Code 2025 is the Labor Code 2025 is a consolidated and updates the provisions from earlier Industrial Dispute Act is there, Payment Wages Act is there, Contract Labor Act is there, Factories Act is there, Social Security codes are there, Industrial Relations Framework is there, unpaid wages are there, layoff compensation is there, gratuity system is there, Social Security contribution are there, all this compensation for work injury, etc. So these statutory dues, whatever is there, it is the first charge on the asset and a new compliance requirement. The statutory dues constitute first charge except IBC overrides. Whatever the statutory dues are there and constitutes first charge except where IBC overrides. Under section 238, overriding clauses as a conflict, IBC prevails, but labor code strengthens the worker claim legitimacy. Even though under section 238, overriding clause is there, but IBC prevails, but the labor code strengthens the worker claim legitimacy is also there. So that's why we have to fulfill the labor whatever the facilities that are provided by the companies under the labor code. And during claim verification, the RP must additionally check real-time digital muster rolls, attendance systems, National Worker ID database, National Worker ID, Unified Social Security Code Register, digital wage slip, and during the verification of the claims, particularly whenever you are acting as an IRP or RP, and in the coming days also, whenever the claims are there, the claims are to be verified with real-time digital muster rules. You have to verify whether the claim is genuine or not. Attendance systems, you have to verify. National Worker ID database, whether the employee, the claimant is there in the National Worker ID database or not. Unified Social Security Code Register also verify. Digital wage slips also you have to. This reduces the fraudulent claims and helps the faster claims verification. So in the coming days, you have to verify this one to arrive the conclusion that the claim is a genuine one. And the restrictions on a termination or retrenchment during CIRP. If at all you are going to retrench or termination of any employees during CIRP, the Labor Code 2025 limits termination or modification of employment terms during CIRP. No mass retrenchment without statutory approvals. 60 days notice to the labor authorities to be given. Mandatory consultation with the workers committee. These three are important. Okay. The particularly, if at all you don't require the manpower, abruptly don't retrench, but a sufficient notice to be given and no mass retrenchment and mandatory consultation with the workers committees also. You have to do. Then only you have to do the retrenchment other. RP must ensure continuity of essential manpower for going concern operations. And RP must ensure monthly payment, EPF contribution, ESI contribution, gratuity as accruals. Once you are continuing the employee as a going concern, you have to do the monthly payments and or EPF contribution. All these things are to be fulfilled. These continue during CIRP as a CIRP cost, even past due remains unpaid. So these are the very important one. During CIRP, the EPF contribution or ESI contribution or gratuity accruals, whatever it is there, that is to be paid promptly. Contract liable responsible transfer to the corporate data. Even a contractor's default is there. Suppose you have engaged, your company has engaged contract employees from some agency. Wage liability is there, safety obligation is there, accident compensation, or legally transferred to the corporate data, and the RP must verify such claims. So here in the coming days, if at all any employee died or any accident compensation not paid by the contractor labor, that is also to be paid by the company corporate data. That is also to be verified. That is also as a claim as a part of the wages or salaries like that. So even contractors default, and the contractors default means if at all the company is engaging the agencies for labor, if the contractor is failed, that is also the obligation of the company. Claim settlement workflows during CIRP under labor code. Public announcement inviting applications. You are inviting the includes specific directions of workmen per new labor code formats. So public announcement, whenever you are giving that public announcement, now you have that form is to be modified. That includes specific directions for workmen for new labor code formats. That is also to be provided. Step 2, verification using labor code register. And here, mandatory registers are to be maintained by the company. That is 21/11/2025 onwards. Wage register digital, attendance register, shift or overtime register, social security contribution statement, hazard or accident register. This is to be verified. Once these related claims are there, you have to verify the concerned registers also. And categorization, particularly category or classification under IBC, IRP or RP period wages. It is a cost of CIRP and the priority. Pre-CIRP, it is an operational date. Social security of IRP period, CIRP cost. Social security of pre-IRP, government dues, that is, and a compensation for injury, statutory dues, IBC priority. Like that, the categorization is also required. And the importance of NCLT principles relevant after sub wages after insolvency date, CIRP cost. Workman ranks pari passu with the security creditor even during liquidation. Contract labor or workmen of the corporate data, if supervision control established, delay in claim filing cannot be eliminated the workers' rights, and gratuity cannot be waived in resolution plan unless funded. So if at all it is funded, definitely in the resolution plan also this is to be factorized. And the role of IRP must ensure going concern operation, deployment of essential staff, statutory compliance under the labor code, registration of all workers in the labor registry, digital labor registry. In that registry, all the labor to be registered, and number will also be allotted, and a timely deposit of EP, PF, ESI during CIRP also, clear communication with the union, worker committees, etc., etc. So as an IRP or RP, you have to follow these guidelines during the CIRP process of clients. If at all the IRP or RP not follow, penalties and the labor code, you are going to invite. Contempt proceedings also. Objections before NCLT. Resolution plan resection. Disruption of operations, strikes and lockout. So that's why if you take into consideration this one, if at all anything happened, definitely it affects on the functioning of the IRP or RP. Once it is non-compliance is there, unnecessarily you are inviting the penalties under labor code. Even though the company is facing some problem, and this is also burden to the company. And the contempt proceedings and the the Minister of Labor and Employment, they will give some show cause notices and other things. And if at all our side any lapses are there, then we are answerable for that. And objections before NCLT. Once NCLT also, they don't, they always give the various other regulators instructions also. So sometimes the NCLT also they comment about the mistakes of the IRP or RP. Resolution plan rejected. Once during that time, if at all the wages are not part of that particular resolution plan, whatever the pending is there, if at all it is not mentioned and the resolution plan is approved by the committee of creditor and submitted to NCLT, definitely the NCLT will reject that resolution plan also. Disruption of operations. If at all you are not giving whatever eligibility is there as per labor code to the employees or the workers, definitely they will start the strike or lockout. Thereby, it is gives a further discomfort to the IRP or RP. Definitely, the stoppage of work leads to the going concern is abruptly stopped, and the thereby some side effects will also be there. Resolution plan requirement as per amended guidelines. A resolution applicant must provide full payment of a CIRP period of wages. Treatment of pre-CIRP dues of workmen and employees, and the social security to be continued. Health and safety measures of the under labor code to be continued. A workforce transition plan to be mentioned in the resolution plan of the resolution applicant also. Settlement of statutory dues, EPF, the Employees Provident Fund or ESI gratuity provision. NCLTL will not approve the plan that violates the worker protection or protection guarantees. So in the coming days, particularly if these are not happening, then automatically the NCLT will also not approve the resolution plan. During CIRP, IRP or RP implement the labor code. The legal areas of the statutory obligation or operation steps of the IRP or RP must satisfy the four new codes. So you no doubt at all, there is no exemption at all to the IRP or RP not to implement this one. Effective from 1st November 2025, whatever the cases you are handling, this is to be addressed when they continue to corporate data as a going concern during the CIR. So here, up to this point of time, I will stop, and any doubts and clarifications are required, please tell me, sir. Then I will clarify the doubts and clarification. After that, again, I will discuss the rest of the things. Sir, madam, up to this point of time, whatever doubts are there with regard to Labor Code 2025 and the subcodes, and any doubts are there or not? Am I audible, sir? Hello?
So you are very much audible, sir. You are very much audible, sir.
Yes,
Ah,
sir.
ah. Any doubts are there, sir?
Not to me, sir.
Sir? So 21st November 2025 onwards, one more the obligation or fulfillment as per the regulatory guidelines, that too The regulatory is nothing but a Ministry of Labor and Employment. That is to be fulfilled in every company. If the company is under CIRP, the role of the IRP or RP or the liquidation in case of liquidation, if the company is a going concern, definitely this code, the labor code, is to be implemented in toto without any dilutions. If dilutions are there, the IRP or RP or the liquidator has to penalize, and some litigations, all these things unnecessarily we have to invite. So for smooth, tell me, sir.
Sir, I have one doubt.
Tell me, sir.
Just tell me if any this registered professional is appointed
Mm,
and he has a case of a running company,
mm.
and this company is running means since a long period.
Sir.
So whether he has make a two criteria of the compliance checklist for under labor law, one is before 21st November and one is after 21st November 25.
Yes, sir. That is, what is your question, sir?
Means if a resolution professional is taking care of any going concern company,
Mm,
and then in that case,
mm.
that company, that resolution professional is required to check
No,
in
you
the
are
laws.
the whoever is a competent, the professional you are going to appoint, he has to verify from 21st November 2025 onwards.
So it means there is two criteria. One is 21st November 2025 is
Mm.
one criteria, and other criteria is 21st November 2025.
He has to give much attention or focus on 21st 11 2025.
But what about this previous period?
Previous period, sir, actually, yeah, the code itself, whatever the previous guidelines are there, that is not fit for the employees or workers. That's why they formulated one code. That code is to be implemented from 21st November 2025. That after is important, sir, not before.
Okay.
Second one, whenever before any claims are there with regard to workers or employees or any is there, that is to be verified with the relevant ledgers and admit that particular claim. But here, the code is, suppose you are handling one CIRP and last month only you have started, 2 months back only you have started. Now the third month is running. So from 21st November onwards, whatever the new guidelines are there, whether the new guidelines are implemented by the HR department of the company or not, that is to be ensured.
Okay, got it.
Okay. The legal areas, particularly statutory obligation, operational steps, an interim resolution or resolution must satisfy under the four new labor codes effective from 1st November 2025 when they continue the corporate data as a going concern CIRP. The four codes, one is the Code on Wages, Industrial Relations Code, Code on Social Security, and the Occupational Safety, Health and Working Condition Code. That is fourth one. It is coming to effect of 21st November 2025. If IRP runs the corporate data as a going concern, wages and salaries of the employee who actually worked during CIRP and the CIRP cost as the first priority under IBC must paid in full before many other claims, that is practical consequences. IRP or RP must ensure timely payment of wages and salary related dues for those working during that period. Sir, here, once after 21st 11 2025, please ensure that all wages and salaries are to be paid promptly. If not promptly, then they will approach the Commissioner of Labor. Then automatically some problem will arise. Separate statutory obligation under the new code, whether it is a wages or social security contribution or safety or industrial related, remain the employer's responsibility, and the principal obligation must be rest with the corporate data. That's why IRP or RP acting as a manager must ensure the compliance while the business is run. Non-compliance can attract a penalty, prosecution, and the claims of which affect CIRP outcome. That's why once the date is there, after that date, meticulously you have to follow the code also. Areas of statutory provision of IRP or RP to be addressed. What are the areas to be addressed by IRP or RP? First, payment of wages, salaries, overtime, and inclusion of CIRP. Action required. Ensure every employee who actually working during CIRP when CD is a going concern receive salary and wages and allowance overtime relevant pay period. They should normally CIRP have top priority under section 53 of the waterfall. Keep detailed attendance payroll records proving that employees actually worked. Why? Courts or IBBA guidance treated the wages, those actually working JRP first priority. IRP or RP must therefore budget for these payments before other distribution. Before other distribution. If not happen, key obligation. Pay at least applicable minimum wages and comply with the revised definition wages under the code of the wages. So whatever the earlier basics are there, that basics may not be correct. So whatever the minimum basic the wages are defined under the code, the same to be implemented. Pay wages within the time specified. Maintain the wage register and pay slips also you have to give correct calculation payment of overtime, holiday pay, applicable bonus, rules wherever applicable under the code. Even once you are paying the overtime also counts for bonus calculation. Bonus calculation. So the bonus also eligible. Earlier, all these things they have not bothered, but stringent guidelines are issued by the Ministry of Labor. Action required. Immediately verify the wage structure, basic allowance, ensure payroll aligns with the code wage definition, update the payroll calculation if required, and maintain the wage register for audit purpose also. So here also, whatever the action required is you instruct that HR department whether they have revised the basic salary or whatever the benefits are there as per the code or not, that is to be ensured. For this, if at all you ask, the HR manager will tell all are fulfilled, sir. Get the confirmation and they keep it with you. Otherwise, you are held responsible as an employer. Now, earlier the corporate debtor is the employer. In the employer steps into the shoes of the employer by the IRP or RP. And social security, PF, ESI, gratuity, etc., etc. Earlier, the gig and contract for the workers, they are not eligible for PF, ESI. Now they are eligible. So here, what is your obligation? Ensure employee and employer contribution to EPF or ESI are equivalent to social security introduced, modified by the board. Code are calculated and remitted on time. You have to ensure. Gratuity and other accrued socials must be computed and shown in claims, and code widens coverage including gig or platform and other. So action is required. What action you have to require? Reconcile PF and ESI ledgers up to date to CIRP commencement date and during CIRP also. So here you need not take the services of the competent person before, or if any person is required to support to the IRP or RP or liquidator, they can get that particular manpower subject to approval of the COC. There is no problem because if at all are you are handling, suppose a number of workers are there, number of claims are there, both operational creditor as well as a financial creditor. In that case, one RP, yeah, the IRP or RP is unable to handle the volume of works, ensure remittances due for pay periods during CIRP are paid provided for the CIRP cash flows. Whatever the CIRP cash flows are there, from that only you have to pay. Identify the contractors or gig workers who may now fall under social security coverage and register, subscribe where required. So earlier, these people are not comes under social security like a PF, the PF or ESI. Now they are eligible. Whether they covered under this new code or not, that is also to be ensured. And occupational safety and other things. That is the fourth code. Maintain required safety measures. You have to visit to the plant and machinery or the production department. Appoint safety officers if a headcount and industry trigger applies. So safety officers after the benchmark, you have to take the safety officers also. If safety officers are not there, if any accident happen, then you are held responsible. That's why if the headcount is crossed the benchmark, you have to appoint the safety officers, ensure medical facilities, first aid, conduct risk assessment and safety audits. So medical facilities, first aid, or medical officer of a certain people, you have to appoint the medical officer nearby, and accident reporting to statutory authorities when incidents occur, and maintain the record of incidents, safety training, and the PPE distribution. All these things are there, and action required. Immediately run the safety compliance check. So once you are taking over that particular the company as a IRP or RP, so for this safety, you have to take the safety compliance check, safety officer, logs, personal protective equipment PPE, emergency response team, prepare incident reporting procedures, ensure any past non-compliance is disclosed and remediated as far as possible. So here also your role is there. Your role is not simply they follow the rules and the regulations or the code of IBC, but also the labor code. But I'm not asking you to verify each and every by you, but you take the assistance of the competent person to oversee this one. And if at all HR manager is confirmed that all these things are completed, then take the compliance report from him. Later on, it supports to you also. And the industry relations code, the trade union, collective bargaining, layoff, retrenchment, and closure of the controls. For this also, your obligation. What is your key obligation? Respect registered trade unions. No, I'm answerable only for COC, not to others. I'm answerable to NCLT. I'm not answerable to any others. That type of this one is not correct. You have to respect and regard the trade unions negotiation, consultation requirements, follow statutory procedure for layoff, retrench, closure, including notice and compensation provisions, if these actions are contemplated. Many procedural protection remain. IRP or RP cannot arbitrarily terminate employees. without following statutory process. So if at all you want, okay, the going concern, the employees are not required. Okay, you can terminate, but notice is to be given. You have to pay the compensation, government permission whenever required. That is also to be followed. That is also to be followed. Otherwise, simply retrench means then automatically you are inviting the other disputes from the Ministry of Labor. Here, the action required. Before any workforce reduction, check threshold and approvals under the Industrial Relation Code and document consultation with the unions and representatives. So, whatever you are doing, in addition to COC, now if that is a going concern and the number of employees, the number of the workers are there, then you have to consult with the particular the unions or representatives of the employees or workers. IRP or RP should avoid unilateral retrenchment without a legal compliance because that invites litigation and add claims against the estate. So once you are simply removing without any cause or without any notice or without any process, definitely, even though the worker is not working for the company, you have to pay the claim also. So that's why it is better to follow. It is better to follow the procedure that are defined under the labor code. And principal employee liability for contract outsourced workers. So, key obligation under the code, principal employer can be held liable for contract workers, wages, social security, and safety obligation in many circumstances. Suppose some contract outsourcing is there, some areas lifting that particular object through crane that is given to outsourcing agency. But outsourcing agency, they have wrongly handled and a number of workers are died. Then if outsourcing is not paid, that compensation to the died people or dead people, then automatically that obligation pass on to the employer also, the company also. And action required. Identify the contract labor engaged through agencies. Ensure contract have complied with the statutory remittances and welfare requirement. Where contractor fails to pay, statute law expose the corporate debtor, hence IRP or RP to be liability. So once any contract is given by the company during CIRP, then the contractor failed whatever the minimum precautions that is to be taken, for that also the IRP or RP is held responsible. Held responsible means the compensation to be paid from the company only. Now, if the contractor fails, all these things are brought to the notice of the committee of creditors and get it approved, and whatever the Ministry of Labor, the notification or government orders are there, that is also to be enclosed. Key obligation, particularly record keeping, registers, returns, and statutory filing. That is also important area. So even though you are paying salaries, even though you are paying a PF or ESI, and even though you are paying that salaries, minimum wages for the outsourcing or other people, still the record keeping is also required. That is a statutory obligation of the Ministry of Labor. So maintain statutory registers. You ask the HR manager, and attendance, overtime records, social security return, safety logs, muster rolls, leave registers as required under the new codes. Whatever the standard formats that are designed under the labor code, that is also to be implemented in the company. Even though the company is under CIRP, the registers are to be maintained properly. This is the labor code directions. File returns. So company, okay, company is under CIRP, company is under going concern. The returns are to be filed with the Minister of Labor. Minister of Labor. So Minister of Labor means that returns, whether the returns are going timely or not, that is to be ensured by IRP or RP. Timelines. If at all timelines returns are not submitted, then penalties will impose. Then it is a burden to the company. And sometimes, if at all that is the IRP is not taken into consideration, the whatever the penalties are there, the penalties are to be recovered from personal from the recovered not the part of the CIRP cost. The expenses are to be borne by the IRP or RP personally. So that is also file returns labor authority social security in time. Many central and state rules required the courts will be prescribed limits. If that limit is the cross, then penalties will impose. Action required. Preserve the centralized labor records. If digital filings are delayed because of management change, prioritize completing them. Okay, during transition period, if at all small things are there, that they will allow. They don't impose the penalty. But even after taking over that particular company, 2 months completed, still you are not filing the returns to the labor ministry, definitely it is a penalty will be imposed. And the special categories, particularly women, night work, fixed terms, gig or platform and domestic sectors. Key obligation. The code addresses new category, fixed term, gig and add protections. If the corporate data uses such workforce in that particular company, you are continued as a going concern. If night workers are there, or woman is there, or part-time is there, all people, if corporate data uses such worker, verify the coverage, social security contribution. That also you have to verify. Not only that one, action required. Map the workforce category and ensure each is treated as a correct scheme. That also you have to verify. And statutory penalties, prosecution, liability exposure. What is the key obligation? Non-compliance may lead to penalties, prosecutions, or attachment of the complicate which complicates CIR. Once these are obligations are not fulfilled, definitely it will lead to penalties. It will lead to prosecution. Thereby, it interrupts the smooth functioning of CIR. The IRP or RP should flag outstandings of the prosecution, notice from labor authorities, and address them part of the risk assessment. So that's why whatever this one is, that timely you have to address, action required. Obtain legal and regulatory status report of HR, all legal and remediate or disclose information memoranda for prospective resolution applicants also. So once these are amounts are to be paid, this is also to be included in the resolution plan and informed to the prospective resolution applicants also, whatever the dues. Otherwise, if the company is given to the prospective resolution applicant without mentioning all these things, then it will be a problem. And the treatment of employees claims under IBC, priorities and proofs. What to do? Collect the claims of the work promptly and verify them. Separate claims, wages, salaries, and CIRP, workmen dues, prescribed period, and section priority in liquidation, and statute rules. Keep proof of payments and attendance, which determines the priority. And the payroll attendance, you have to verify. Pull out the payroll for the last 6 months. Reconcile with the bank statement and attendance. Whenever you are paying the claims before CIRP, first you pull out the payroll and attendance reconciliation. And as per payroll, they paid, particularly the amount is credited to respect to savings bank, then it is a correct process. Today, the fraudulent transactions, that is a PUF transaction, PUFE, PUF, preferential undervalue, fraudulent and extraordinary transaction in the real estate sector or in the infrastructure sector, the ghost employees are more. Ghost employees, GHOST, ghost. The ghost employees means one company requires only 20 people and 200 employees they will appoint. That is contract labors. And they will take the amount of the 180 and 20 genuine they will pay. Remaining 120 they will swallow. So that's why pull the payroll for last 6 months and reconcile with the bank statement. The same amount is credited to the respective accounts of the employees, outsourcing employees or not. Identify employees who actually working during CIRP need to be classified. So verify some of the corporate data. Without some people they will appoint and they don't do anything. But if you see the NCLT Calcutta case, no work, no pay. If at all work is not there, remove that employees. But in the today's condition, labor code, you have to take the permission of you have to inform to the associations or unions, etc. Pay run for CIRP period. Ensure wages for immediate pay period are dispersed on time. Allocate and CIRP funds accordingly. So here also the lot of importance is there. Timely repayment. If at all delayed, then automatically it attracts a penalty also from the ministry, labor ministry. Reconcile employer and employee contribution. Whatever the provident fund is there, whatever the gratuity is there. Earlier also, the even some of the companies pension, the employer and employee contribution is also there. Today, on account of national pension scheme, that is also they have they designed some companies or some organization. That also you have to verify the claims. While verifying the claims, you have to reconcile the employer and employee contribution remitted and unpaid during the CIRP. Document a plan for CIRP cash budget and safety and OSH, operational health and safety audit is also. So whether the production department is in safest condition or the workplace are in safest condition or not, it is very difficult for the IRP or RP to know whether it is a safety condition. For that, you have to take the auditor, safety officer, appoint the safety officer if required, and he will give the information about the safety of the company. If that is given, that also to be filed. In case of any accidents comes and the labor, they will ask a higher compensation and it protects the safety audit report protects to some extent for the IRP or RP. Trade union communication. Being a IRP or RP, you have to close liaison with the union or association. Otherwise, they will start dharna, strike, lockout, all these things are there. So instead of that, Maintain the cordial relationship with the union and employee also. And contractor outsourcer workforce check. Get the agency agreements. Some of the companies, they will give even a Larsen and Toubro also, L&T also. Some of the subcontracts they will give, outsourcing they will give. Whether the outsourcing agency is a reputed one or not, in case of any claims that are happened to that particular activity, if they have not paid, the corporate debtor has to pay. So that's why you have to revisit that contracts once again, whether the outsourcing the companies are good or reputation is there or not. And the claims intake and classification. Open dedicated claims trust account for employees' claims will legally required file the claims prescribed under IBC format and classify the claims CIRP, workman priority or unsecured, etc., woman priority, etc. Document and disclose. Maintain the detailed records, attendance, payroll spreadsheet, bank confirmation, and include labor compliance, liabilities, and a discrete section of the information memoranda provided to the prospective applicant, resolution applicant. So in the new scenario, particularly employees and the wages, whatever the dues are there, that is to be protected. That is to be protected means you have to inform the details of this one. If at all any labor code issues are there, claims are there, or any the penalties are there, all these things are to be disclosed to the prospective resolution applicant. If at all it is a part of that particular resolution plan, mention that one. Even in the information memorandum also, all these things are to be mentioned. Legal and compliance advice. Obtain the rapid legal opinion on critical issues, pending prosecution, outstanding statutory notes, and likely large retrenchment exposures. So for this also, from time to time, you have to get or you appoint the legal experts who are having good command or grip on labor code or earlier labor act like that. So in a case of any issues are there with the commissioner of labor or employment, he will address. Otherwise, simply not to accept their correspondence may lead to some issues also, legal further issues also, budgeting and cash flow. Because now this labor code is a new one. Salaries definitely will increase, wages will also increase, and you have to give the employment offer letters, and even the ESI and the Provident Fund, even a temporary and outsourcing are also eligible. For that, the amount of wages will increase. So for that, budgeting and cash flow is also very important, including all necessary wages, social security costs in monthly CIRP cash flows projection. Ensure that these are prioritized. Being a IRP or RP, this is also to be taken into consideration. Documents and templates, IRP or RP should collect immediately. Payroll register, attendance register, biometric logs for 24 months are available for the period. If at all you are promptly paid, no, to be included in the particular liquidation or whatever the on par with the secured creditors. So the payroll registers are to be collected and keep it with you. Attendance registers, because some wrong claims and fraudulent claims will also be included. Biometric locks are also for 24 months, whether the worker or employee reported to the organization on the specified dates or not. Bank statement showing salary disbursement. That is also to be ESI, ESI, PF for chalanas that is remitted by the companies, that also to be collected. Document required for collector, contractor agreements. If at all the corporate debtor is engaged in the services of outsourcing contracts, that agreements, trade union registration, whether it is a recognized one or not. If not, you need not contact those people. Only recognized unions only you have to interact with the people, collective for collective bargaining and past industrial disputes. Safety audit report. Suppose the production department or in the sites, whatever the safety, the audit reports are there, accident registers are there, all are to be gathered and keep it at one place. Or any labor notices, show cause notices, prosecution files that is there with regard to Ministry of Labor or Commissioner of Labor, that is also kept in one place. These assist a classification of claims and demonstrate who actually worked and when he worked. For that purpose only, these are supplementary information or cross-checking is possible. Litigation and strategy point to watch. Classification of claims. Court emphasizes proof that employees are actually working during CIRP for wages to be CIRP cost. Keep contemporaneous proof, attendance and workers. Some of the workers, without working also, they will claim that type of claims are more, particularly in the CIRP time. So that's why whether that a particular person is working, even though the association, they submit a big list, whether the list is cross-check with the books available, payrolls available, bank statement available, or ESI, the Provident Fund statement that names are there or not, and income tax also. So once the particular employees or workers crossed the threshold limit of the salaries, definitely the TDS will applicable. The TDS cross check is also required. Otherwise, wrong claims are to be not to be admitted, and principal employer exposure. If contract agency failed to remit the corporate data, IRP may be held responsible. So sometimes outsourcing agencies, they will take the services of the outsourcing for the company, but they don't pay. In that case, the claims are to be paid by the company only. If outsourcing company is failed to pay the amount, so in that case, once the company during CIRP means that is IRP has to held responsible. Investigate the necessary, bring a recovery action against the company. Once it is to be paid later on, that is to be recovered from the outsourcing agency. Labor authorities, states will rolling out the rules under the courts. Different states may have procedure difference coordinate with the state labor department regulator where a plant or office is located. So here, particularly the labor code is a central code, but sometimes the minimum wages and the other conditions state-wise is also there. You have to follow the state-wise where this particular the factory or the workplace is located, and you have to follow that guidelines also in addition to that central guidelines. Where law is changing, IRP should be cautious. The new codes are broad implementation rules issued by the central or states. Some compliances process may still be clarified in notification rules and slightly different approaches. IRP should monitor the notification and state level rules while when preparing for filings and compliance schedules, etc., etc. Not only that one, the useful authoritative references. So the government, the Press Information Bureau of India, particularly that they have given information, Ministry of Labor and Employment, IBBI notice or guidelines or Section 53 material on priority, all these things for updates are also you have to go through to admit the claims. Not only that one, recent practices notes and employer obligation, case laws, if any, or NCLT orders, if at all in this case are there, all are to be verified for prompt payment of the particular employees or workers' wages, or not only that one, the employers, the claims are to be admitted or not to admitted. This depends upon the references, whatever I mentioned. That is very, very useful. Finally, you have to give one notice to the employees also. Dear colleagues, the company is under CIRP, and IRP or RP is operating the company as a going concern. Wages for employee who have worked during this period will be processed as a priority. Please continue to attend as per the roster. For queries and claims, submit your supporting attendance and a payroll document to the HR claims desk at we will engage with the union representative and keep you updated. So otherwise, the employers and the workers, they may treat what will happen. They are in dark. So being a IRP or RP, you have to address notice in the notice board. You put in the notice board. Don't be panic. Continue the operation. But during CIRP, whatever your salaries are there, I will protect even as per Labor Code 2025 also. And anyhow, we are interacting with the unions and association. And from time to time, they will disseminate that information to you. And if that type of information is provided to the workers or unions, then the particular workers and unions, they are also happy. They are also cooperative with the IRP or RP during the CIRP, particularly during the this one. What is that one? Going concern. Otherwise, they are panic. And some people they even without consulting the unions and association, they are going on strike. And whatever lockout, whatever it is, they will do. And thereby it disrupts the day-to-day function. So in that case, IRP has to stop his core areas and concentrate on other areas, which leads to the delay in completion of the CIRP. So the quick recommended template text for employees communication is also very, very important. Using such transparent communication reduce unrest and helps establish who actually worked during the CIRP period. So they are having their own feelings. My salary will get or not, whether I am getting the full amount or not. All these things are there. So to reduce the panic condition, the IRP or RP, they have to send. So I have reported as per the NCLT order, so and so as a IRP or RP. So for the next 180 days, I will continue as an IRP or RP. So in the meantime, please extend your support. I am here for reviving the company. Or if not possible, I am going to hand over this company to the prospective resolution applicant. And if not possible, the liquidation. That message also to be given. Otherwise, if the people have started resignation, and if there is a scope for reviving the company, that is not possible. The going concern also depends upon proper communication. So using that transparent communication reduces the unrest of the employees or workers and helps establish who actually worked during the CIRP period. This type of the communication is very much required. So with this, I'm concluding my today's discussion. And any doubts are there, sir? Any doubts, sir? If there is no doubts, I will wind up. But the final concluding remarks is, during CIRP, whatever the latest labor code is there, the latest labor code guidelines are to be fulfilled. Otherwise, unnecessary disputes, unnecessary complication, unnecessary litigation will arise through the Commissioner of Labor. So this code is, when compared to the 29 acts, replaces with the code. Mostly this code is applicable in case of the company as a going concern. So some of the companies, Nagarjuna Fertilizers or some manufacturing companies, even though they are defaulted with the financial creditor or operational creditor, the CIRP process will come. It doesn't mean the company will stop. So the activities will continue. So you are going to act as a IRP or RP to continue the company as a going concern. During that going concern also, this type of a code, the code guidelines are also to be properly implemented. With this, I'm concluding. Thank you very much for your patience listening from 2 o'clock onwards. And thank you very much to ICSI, IAP also for giving an opportunity to discuss about this one. Thank you. Good night to all.
Thank you
Thank you,
very
sir.
much,
Thank you
sir.
for the
Thank you, sir.
enlightening
That's
session,
very
sir.
Thank you, sir.
insightful.
Thanks
Thank
a
you,
lot.
sir.
Thank you very much, sir, for giving your valuable time and sharing your experience on the topic.
Okay, sir.
So I
I'm
request you
closing.
to share the slides if possible.
Yes, morning only I sent that
Yes, sir, I
PPT
will
to.
share the slides along with the CP confirmation.
Okay,
Thank
thank
you,
you.
ma'am. Thank you.
Thank you, ma'am.